you, my lord. Can I start off by answering Lady Arden's question as to the fact of a grant of development permission to subdivide land? And the answer is simply this, is that it authorizes the type of structure that can be built on each of the subdivided plots. But it does not authorize any actual construction to take place, nor does it authorize the principle of how the building will look like. But it does authorize the use for which the lot could be put. And if I could just use this opportunity to explain, the board has seen and has been referred to Section 29, which sets out the various forms of development permission. And you will see from that that the scheme is there is the possibility of a step-by-step or a stage-by-stage process. And the reason for this step-by-step or stage-by-stage approach is to allow an applicant to proceed along each stage with some degree of legal certainty. So, for example, if you were to apply for, and there's no requirement that you must do it at each particular, that you must start at one stage and then go to another stage and another stage. It is quite possible, and it is often done, certainly in these islands, that you can make an application for detailed development permission without any prior applications. But if you do that, you run the risk that the application might be refused because the land use, if there is no prior land use, the land use might be refused. And so in this case, this is what the applicant did, the respondent. It adopted the stage approach of first seeking permission for the use to which the land was put. And this is done. There is no separate application form for a change of use. The only application forms relate to subdivision, outline, and detailed development permission. And you can, I had referred the board to the actual application to subdivide this land, which was made in 1994. And you will see that in the supplementary bundle, it starts at page 3. And then there are a number of questions that are asked on this form. And at item number 4, you are to give a description of the proposed subdivision, including the number and use of the proposed lots. And to see how the grant of an application to subdivide land is treated when a subsequent application is made and what is considered. An example is that is the development permission that was refused and to which you were referred to by my learned friend. That's at page 442.
Forgive me, Mr. Missick, before you move on, can you just help us in relation to the block and parcel number on page 3?
Yes, this was in respect of both the peninsula and Siliki. 58 was the peninsula, and 4 was Siliki.
And where do we see
that on page 3? Under item 3 in the application form, at the bottom of page 3. there's a description, the block and parcel number.
Yes, I see. Thank you.
Yes, yes.
It doesn't seem to be in the heading, but it is there in 2.
Yes.
Yes, thank you.
Yes. So yeah, so I was about to refer the board to page 442 in the electronic bundle, and this was a case where an application was for detailed development permission was refused. This was on the peninsula, not on Silly Key. And as you see, it was for Villa Capri Development Company was the applicant. And this was parcel 129 and 130. And there was supposed to be 4 condominium buildings and various other developments. And then there's a refusal dated the 8th of May, 2001. And the reason for the refusal is given as follows. From outline planning application PR 3213, the master plan, and detailed planning application for development of the entire Silly Creek Peninsula, it is evident that the site for development is earmarked for condos and villas, plus this type development. So pausing there for a moment, you will see the planning authorities or the board is describing condominiums and villas as a type of development. Then it goes on to say, the board is satisfied that the proposed land use is consistent with a development plan or master plan for the peninsula. So the board obviously would consider, when considering any application, whether or not there's an existing land use permission and what that permission is. Then it goes on, notwithstanding the aforementioned and adherence to provisions of Section 34 of the Physical Planning Ordinance, the proposed 3 floors and height of the buildings is unacceptable. If allowed, the proposed building height and number of floors will set undesirable standards, which will prejudice future planning on the peninsula. So you'll see when an application was made for development permission, based on an existing land use, is refused, not on the basis that the type of development was unauthorized, but on construction details, such as another detail, for example, the height and number of floors of the building. Yes, my lord.
I think I should register that, speaking for myself, to use the phrase permission for subdivision as indicating an agreement in principle to a new use seems like a misnomer. I would ordinarily have thought that that would be a matter for outline planning permission. Is there anything in the text of the PPO that indicates what one achieves by making an application for permission to subdivide?
My lord, no, there's nothing in the text itself, except the application form which I just referred the board to, which shows that it is the you are required to say the purpose for which you are using the lots. And
Mr. Missick, my difficulty is that on your account of the way planning permissions work under the PPO, in fact, the key application is the application for permission to subdivide lots. And I was just wondering whether there's any indication from the PPO itself that shows that, in principle, that may be the main point where the principle of development is decided.
No, my lord, I would not go that far. I can't go that far. Not the principle of the development, but certainly because the principle of development would involve more than simply the land use. It would involve more detail as to the size, height, setback, facilities, and various other matters. But the critical point, which in my submission is resolved when subdivision is authorized is the use, is the land use to which the divided lots could be put.
Yes, thank you.
Could I ask a question that follows that, Mr. Mizik?
Yes, yes, my lord.
I appreciate you're going to bring us to the 1994 Development Commission, but we were looking a little earlier, if you recall, at the condition that stipulates what it does relating to outline permission. Do you submit to the board that that looks forward to an application for outline permission, which would establish the principles that you've just referred to?
Well, my lord, what I will say about that is this: is that that permission, the 1994 permission, did not, when it came to the governor, although this was authorized by the board, this was purely a recommendation to the governor. And when it came to the governor, before the Executive Council in 1995, the governor did not approve the subdivision as it related to Silly Key. So this application was not any approval in relation to Silly Key. That no approval was given before 2006. And in 2006, the approval when given was unconditional. Unconditional application to subdivide the land. That is the way I put my case.
So no approval relating to Silly Key was given until 2006, and that was in the 2006 settlement agreement.
Yes, my lord. That is the basis of our case. Yes.
Yes, thank you.
So with that, can I now move straight into the question of whether or not the 2006 settlement agreement was the grant of development permission in relation to Silly Key. And I, of course, limit my submissions to the grant of development permission to subdivide land. Now, the appellant agrees that the settlement agreement authorizes the type of structure that could be built on Silly Key. And you will see that from page 112 of the electronic bundle. Sorry, page 122 of the electronic bundle. It says TCIG expressly covenant to permit, to facilitate, and support the carrying out of the development. Although the LUP identified the type of structures authorized to be built on Silly Key, it was always the case that the respondent would have to make applications for detailed development permission in the normal course before any structure was built. This was to ensure compliance with relevant construction standards and any other related legislation, in particular Section 4 of the National Parks Ordinance. So that is our case, is that the type of structure was authorized, but we would have to seek detailed development permission. That is how the appellant understood it, and that is how the respondent understood it. And that formed the basis of the Court of Appeals decision in paragraph 76 of the judgment, which you will find at page 105. This is just one of the places the Court of Appeal made this finding. At the bottom of that paragraph, the last sentence of that paragraph, the Court of Appeal says, The development will, of course, be subject to the requirement of detailed town planning and other approvals envisaged by Clause 6.5 of the 2006 lease, which we have found to relate not to the type of development which we found has been approved, but to building standards and the like. So that when the Court of Appeal is talking about type of development, it is talking about the kind of structures that could be erected within the subdivided or on the subdivided parcels. The appellant says that this decision, notwithstanding that is what they say is the effect of the settlement agreement, is that it was not a development permission because it was not one that was made under the National Parks Ordinance. And the board was provided with 3 different reasons. The first one was that there was no application made in the prescribed form. And secondly, that the statutory requirements for permission, including EIA, was never complied with. And the third is that there was, if it had been granted, it was an unlawful fetter on the governor's powers. So if I could address those issues very briefly. First, the application for development permission was made in 1994, and that is the form that the board has just seen, where the application for subdivision related both to Peninsula and Silly Key. That application went through the normal process. All relevant bodies and persons were involved in the decision making. It was submitted to the Director of Planning. The Director of Planning submitted it to the board, and the board approved it, but it is accepted that the board's approval at most amounted to a recommendation. The approval and the application did make it to the governor, because we note from clause 11.3 of the 1995 lease that the land use plan with the stamp of the board's approval was before the governor. And it could only have been, not only was it before the governor as a person, but it was before the Executive Council, which is the advisory body at a political, high-level political level, which makes these sorts of decisions. And the Court of Appeal obviously always entitled to take judicial notice of the fact that in order for a decision of this type to have been made by the Executive Council, it would have been made on the foot of an application of a position paper by the minister. The application was accompanied by the necessary EIA. So as far as the application itself going through the normal process, this was followed. When it came before the governor in the Executive Council in 1995, the governor made no decision on it in relation to Silly Key. He could not make any make any decisions in relation to the peninsula, because that was a matter for the Physical Planning Board. And clause 11.3 of the 1995 lease, the governor deferred making any decision as to whether or not to include Silly Key in the 1995 lease. And there were 2 conditions. upon which the deferral was based. First was that the peninsula development had to reach 60% completion. And secondly, that the nature and scope of the development had to have the approval of the Director of Planning and DECR, that is the Department of Environmental and Coastal Resources. Now, the second of those conditions was a very significant condition. Yes, my lord.
Yeah, yes, Mr. Messick. It was about the second condition I wanted to ask you, because I'm looking at clause 11.3, which is, I think is page 327, and I wasn't quite sure how you got that second condition from that.
Well, you will see the second condition is in the settlement agreement itself when we come to it. It says that condition was satisfied. Is your lordship asking me about the satisfaction of that condition?
Well, looking at clause 11.3, that seems to be concerned with a variation of the lease to include, for the first time, a lease of Scilly Quay.
Yes.
As I'm reading it at the moment, it doesn't seem to be concerned with any question of planning approval itself.
Well, my lord, I was just about to say why in my submission it is.
Oh, that's what I was asking for your help with.
Yes. Well, it was concerned with the important words there was the nature and scope of the development. Nature and scope of the development had to be have the approval of the Department of Environmental and Coastal Resources. Now that department is the very department.
But forgive me, isn't that looking forward to what will have to be done if there is an extension of the lease?
Yes, if the lease was to be extended to include Scilly Quay, yes, that condition would have to be met. But my submission is the reason why it was put in those terms was so that further consideration could be given to the fact that Scilly Quay was in the national park. So,
yes.
So a planning environmental consideration, further planning and environmental considerations have to be taken into account before the governor would agree to include it in the 1995 lease.
But, well, all right, thank you. I think I understand your submission.
Mr. Messick, while we're pausing, can we just take a step back for a moment?
Yes.
Like your help, perhaps I haven't understood what you've submitted to us. If you come back to the 1994 permission to subdivide,
Yes.
can you look please at page 295 of the electronic bundle? Drawing there, stamped by the Director of Planning and dated the 14th of December 94.
Yes.
And the stamp says granted permission to subdivide land. And are you submitting to us that although that shows Scilly Quay and the layout of plots on that land, that the permission granted did not in fact relate to that part of the site?
No, my lord, what I'm submitting, it was approved by the Physical Planning Board, but the Physical Planning Board did not have the authority to grant permission. Only the governor could. At most, this amounted to a recommendation to the governor.
Right. So that's what you're saying, that that's merely a recommendation at that
Yes.
point.
At this point, yes. And the fact that the governor had considered planning and environmental considerations, including those specific to the Scilly Key in the National Park Ordinance, is supported by the letter of March 28, 2014, which is at page 443 of the electronic bundle. And it is the second paragraph. This is the letter from addressed to Mr. Coleman, who was representing the respondent from the Attorney General's chambers. And the second paragraph says, "We have had a chance to review the planning department files, which gives some indication that the government, about 1995, agreed to allow us some development on Scilly Key. The indications are that it was to be a minimal development in keeping with the area being a national park, but that it may have included residences." So this would indicate there was consideration given.
But I'm so sorry, Mr. Missick. That, as I understand it, that's inconsistent with your case as you've just described it to Sir Keith Lindblom, because in fact, no allowance had been given for development on Scilly Key in 1995.
No. I accept. All I'm saying is that as early as 1995, considerations was being given. I'm not relying on this as approval. I'm saying that as early as 1995, the development or the inclusion of the development in an extended 1995 lease, that the question of the national park was in the minds of the governor.
Right. But I mean, it would seem that on your case, this was actually an error of law by the government in this letter.
Well, I'm not relying on as authority for the proposition that permission was granted in 1994. No, that's not. I'm not relying on it for that. I'm relying on it solely on the basis that it was a matter that was in the minds of the planning authorities, and that Scilly Key as an area within a protected zone, that consideration had been given to it, but obviously no decision was made by the governor in 1995. I don't know whether that.
Yes. No, well, thank you very much. Yes.
And the matter did come up again in 2001. As your lordship would see from page 225 of the electronic bundle.
Sorry, could you say the number again, please, Mr. Missick?
Page 225.
225, thank you.
That is the penultimate paragraph in that letter. It says, this is the permanent secretary in the Ministry of Natural Resources, not in the planning department, saying it was recommended by those departments, that is the Department of Environmental and Coastal Resources and the Department of Planning, that the key should remain undeveloped and be retained as an area of outstanding natural beauty for the enjoyment of the existing and future generations of Turks and Caicos Islanders and the residents of Sauk Sound community. So the language of that provision in my submission indicates that it was almost tailor-made in relation to the requirements of Section 4 of the NPO. So again, in 2001, in the context,
oh, sorry, you finish.
yes, go on.
Well, it was really just to draw your attention to the last paragraph on that page, because the point of this letter is to debate whether there should be a lease or not.
Yes, but it was, my lord. But the reason why why it was not to be included in the lease was because of the position taken that it ought not to be developed, that Silly Key ought not to be developed at all. And
Yes,
so,
thank you.
Yeah. And it was against that background that the settlement agreement, it was that letter which led to the litigation. Which was resolved in 2006 by entering into the settlement agreement. You will find the settlement agreement at page 346. Sorry, that's the lease. I do apologize. The settlement agreement is at page 341 of the electronic bundle. And section, clause 1 says, well, before I get to that clause, I should take your lordship to the recitals. Recital 2 refers to the obligations in clause 11.3 of the 1995 lease. And then it refers to the property is included in a land use plan. This is recital 3, approved by the Physical Planning Board on the 14th of December. Then it says Silly Key proposes to develop the property in accordance with the land use plan or any other use plan approved by the Physical Planning Board. And then
But
says,
Mr. Missick, I'm sorry, forgive me.
Yeah.
Just come back to recital 3.
Yes.
I'm struggling a little at the moment. Perhaps I haven't understood what you said to us. To understand how paragraph 3 can be reconciled with what you said to us just now about there having been merely a recommendation relating to Silly Key.
Yes, it's not an effective approval by the governor. All I do is reciting the fact that the Physical Planning Board itself approved it. But I'm not relying on that as being the approval.
It wasn't an approval.
It was approved by the Physical Planning Board, but not by the governor. Or the Physical Planning Board did not have the capacity, the power to do so. So the recital is simply reciting the history of how we get to 2006 settlement agreement.
Right.
And then aforesaid Silly Key proposes to develop the property in accordance with the land use plan. And then 5, that talks about the environmental impact. Then 6 refers to the dispute. And
Mr. Missick, before we move on from the recitals, just looking at recital 5,
yes,
the environmental impact assessment reports were very, very out of date by the time of the 2006 settlement agreement, weren't they?
well, they were old, but there was no indication that the matters in which they addressed had changed. And in any event, what I would submit is that when the application for detailed development permission was submitted, it was open to the governor at that stage to require new environmental impact assessment.
But I thought we'd been shown regulations that said that if you had an application for permission, including, I think, to subdivide, you had to submit an environmental impact assessment with that application. Have I misremembered?
No, my lord, and what our case is that when the application was made, at the time the application was made in 1994, the environmental impact assessment did accompany the application. And what happened in 1995 was that the governor deferred the application. He did not consider it in relation to Silly Key.
Yes, I see. Thank you.
And then clause 1 of the settlement agreement says that the Crown acknowledges that Silly Creek has met all the requirements stipulated in under clause 11.3 of the lease for the inclusion of the property in the lease, and approves the land use plan as it relates to the property being Silly Key. And that is the provision that the respondent relies on. Yes, my lord.
Yes, sorry, just taking you back to recital number 5, who had approved the environmental impact assessment report and who had the authority to approve it? Was that something that the governor had to do and did not do?
No, only it is the director of planning has to do that. He submits the director submits the report to the board together with his comments, and then the board submitted with their recommendations to the minister, and the minister then submits his recommendation to the governor at executive council level. But it is not the governor who determines the content and the efficacy of the environmental impact assessment. That is a matter for the director of planning as his advisor. Yeah, so it is clause 1, which is the provision which the respondent relies on. And the reason why it says as it relates to property, is because this is a recognition that only the governor could have given approval for the use of land on Silly Key. I would also ask the board to note that this approval was unconditional. There were no conditions attached to it. And in doing so, and in considering the effect and meaning and what was intended by this, I would ask the board to also consider the context in which this came about. The context being the settlement of a dispute between the parties. The heart of which was whether or not, sorry, my lord, yes.
Well, I was just wondering whether the fact that it's unconditional might be said to be a point against you, since it would be really quite an unusual thing for the governor to grant unconditional consent for you to do anything you liked on Silly Key, wouldn't it, in the context of a national park?
No, my lord, it's not. It ought not to be a point against me, because as we will come on to see, it was only for the land use plan. It was only for the subdivision.
Yes, thank you.
It is for that particular type of development, the land use itself, and nothing else.
Could I just bring us back to section 4, please, of the National Parks Ordinance? It's on page 573 of the electronic bundle.
Yes. Yes, my lord.
You have it there. That refers to the governor making a grant of development permission for the erection of buildings, the construction of roads and so forth.
And such other development as may be considered, such other development.
Yes.
And development would include a subdivision, as we have seen.
That's what you submit. Indeed, you have to submit that, don't you, to make good the argument you're advancing to us.
Well, my lord, that is, yes, that is, yeah. Such other developments must include and also development is included as part of the definition, including a change of use as well. So
where do you get change of use? I'm sorry.
That is part of the definition of development in both the physical planning ordinance and under the NPO.
Yes, but where do you get it in section 4?
Well, the word development or such other development as may be considered desirable. So this is the first stage in the process to grant development permission for the erection of buildings. But if the governor was of the view that the type of structures that was being proposed was of the type which ought not to be developed in a national park, then he should have not granted.
Well, your argument does. I'm sorry, forgive me.
Yes,
your argument does depend then on reading section 4.1a as embracing a development permission for mere, as it were, mere subdivision.
Yes, my lord. Yes.
It has to depend on that.
Yes. And it is a very, as I said, it's a very limited form of development permission, but it has a legal connotation when subsequent applications are made.
Thank you.
So my submission is that all of the statutory procedures were followed. The governor, having deferred the decision in relation to Silly Key, made a decision in 2006 and approved of the type of development shown on the LUP. That document must have some meaning, it must have some effect. Yes, my lord.
I thought there was a difference between the two developments as far as Silly Key was concerned between 1995 and 2006. Insofar as there was some beach resort in the 1995 one, and there wasn't one in the 2006 document. So it appears to me that perhaps that is a material difference between the two, which might require a separate application.
Well, my lord, the form of the development, or the content of the LUP in 2006, as it's related to Silly Key, was identical to that that was before the governor in 1995. I'm happy to show your lordship that if you would like to, but there was no difference in the content of the plan.
Yeah, I thought there was, but no doubt I'm wrong about that.
Well, my lord, there isn't. If I can show your lordship that now, page 345 is the one that was attached to the settlement agreement. And the one that is attached to the 1995 lease is at page 9 of the supplemental bundle. And I'll leave it with your lordships, but when you look at it, you will find that they are identical.
There is another plan that's 330, but not to worry, we'll go through them. It's okay.
Just while we have a pause, the definition of development in the National Parks Ordinance is different from that in the Physical Planning Ordinance. The latter specifically refers to subdivision, but that for the National Parks Ordinance does not.
Indeed, my lady, it doesn't, but it does include change of use.
But you might to subdivide property with a view to holding on to it for many years, and then subsequently you might want to sell it. That would be the usual course, I've no doubt. But it doesn't necessarily follow that because you're subdividing, there is then a change of use.
Well, no, it depends on what the existing use is and what the contemplated use is. At the time of the 1994 application, it was vacant land. There was no use. And the application was to alter that so that you could build individual, so that you can develop it and build individual units on it. And I know there are authorities under English law as to whether or not a subdivision would amount to a change of use. But in England, there is no subdivision is itself under English planning legislation, as far as I'm aware. Subdivision itself is not part of the definition of development.
Thank you.
And if I could briefly address the suggestion that clause 6.1 was qualified by various provisions of the 2006 lease, starting with clause 6.5. The 2006 lease is at page 346, and the emphasis was placed on clause 6.5, which is at page 355. Clause 6.5 says not to erect or cause to be erected any structure or carry out any works on the demised premises or adjoining water courses without the approval or consent required by the applicable ordinance and subsidiary legislation. So clause 6.5 is not concerned with land use, but building operations. And that is reinforced because clause 6.5 is part of a series of clauses which deals with building operations, including clause 6.3 and 6.4. 6.3 talks about commencing construction and thereafter completing construction and infrastructure. And then 6.4, not to vary or from or leave incomplete any of the construction and finishing required by any clause without the written consent of the Crown and the Physical Planning Board. So the Court of Appeal, in my submission, correctly held that these clauses did not prevent clause 1 of the settlement agreement, or did not qualify clause 6. Did not qualify clause 1 of the settlement agreement. And just to address very quickly the point about the documents being executed by the governor in his capacity as landlord rather than as planning authority. And the decision in Dudley Muslim Association relied on by the appellant. Dudley, in the case of Dudley, there were no permissions at all. There were no approvals at the time the lease was executed. The lease itself in Dudley required dual consent, both of the Development Control Officer, sorry, the Development Control Committee and the planning officer. And there were no other documents issued by the Development Control Committee that had the responsibility for planning. So this is the reverse of what was being argued in Dudley, because in Dudley it was being argued that the council was bound by, council as landlord was bound by the decision of the Development Control Committee as the planning authority. In this case, the land use plan is part of a separate document in the settlement agreement approved by the governor, who was the planning authority. And nowhere in the settlement agreement did he indicate that he was signing this document as landlord and not as planning authority. He could have, if he wanted to, reserve his position as planning authority, simply execute the settlement agreement by providing for the entry into the 2006 lease and make no reference to the approval of the land use plan. But he expressly approved the land use plan. And the reason, going to the question of feta, the reason why no question of feta arises on the basis of the respondent's case is that the respondent's case rises or falls on whether the board accepts that clause 1 of the settlement agreement was the grant of development permission to subdivide land. If it did constitute development permission, there is no question of feta. It was a decision that was already exercised. A discretion that was already exercised and a decision taken. And it was on that basis that the Court of Appeal held that it was not an agreement to exercise a future, to exercise a power in the future. And the reason why, in my submission, the appellants are going down this route of feta is because their case is based on the proposition that the appellant is relying on the provision in the lease to approve of the development. But that is not the appellant's case. And the appellant understood that from the submissions made by the Court of Appeal, and we'll come back to this when we consider the question of legitimate expectation. But if you'll, my lords and my ladies, return to the supplemental bundle at first at paragraph 72 to 75. These are two supplementary submissions made in the Court of Appeal at the request of the Court of Appeal on the question of the law on legitimate expectation relating to, sorry, as it was set out in United Policy Holders Group. And at paragraph 6 is how the appellant, sorry, how the respondent appellant then put its case to the Court of Appeal. The respondent made a statement in the settlement agreement dated October 6 that it had approved the land use plan annexed to the settlement agreement. This is at page 73. This was clear and unambiguous statement devoid of any relevant qualification that the respondent had approved of the type of development set out in the land use plan. So that is how the case was put by the appellant, sorry, by the respondent in the Court of Appeal. So if I can turn to the second of the issues raised in the appeal, and that is whether or not it was possible for the governor to have granted the development permission to subdivide land for the purposes of the structures that were set out in the LUP. And the respondent's submission is that on the true construction of that section, the governor did have that power. The purpose of section 401A, if your lordship and my lady still remembers it, is not to prevent private ownership of land in a national park, but to identify the permissible use and to prevent overdevelopment to achieve the desired objective, that is, public access and enjoyment. And it is our submission that the Chief Justice applied the wrong test by focusing on private ownership instead of whether the proposed development could peaceably coexist with the public's right of reasonable access and enjoyment. You were taken to the National Parks Ordinance, and in the interest of time, I'm not going to ask the board to look at it now, but you will see from section 3, it authorizes the governor to declare any area in the islands to be a national park, and that includes an area that is private land. And you'll also see from section 5 that it envisages that the governor, when he makes an order declaring a national park, which includes private land, he need not compulsorily acquire the private land if the use for which the park is established is not incompatible with the use to which the land is put, the private land is put. He would only compulsorily acquire it if there was some incompatibility. So the NPO itself recognizes that there may be peaceful coexistence between private ownership and the public rights of reasonable access and enjoyment. And in considering whether peaceful coexistence is possible, it is also necessary to consider the purpose for which the park is established under the National Parks Order 1992 by identifying the features of the particular park. And in this case, we would say that the features here, in respect of which the Chief Justice paid very little attention, were those based on the land. You will see that in the National Parks Order and the declaration of the Chalk Sound National Park and the purpose for which it could be used, which include bone fishing and other activities. And so coming to the text of section 4.
Lord Stevens has a question for you.
Sorry, Mr. Missick. I think one of the purposes was having picnics, and I was just wondering how you can have a picnic on some private property.
Well,
sorry, on a building, an area which has been built upon and is in private, and how that is consistent with the obligation of page 573 that national parks shall be open to members of the public.
Yes. Okay.
Recreational use.
Yes, my lord, the word open to the public does not mean that the public must have unbridled access to every square inch of land in the park. It is to be open for recreational purposes. You will see from the land use plan that was approved by the governor, it includes various public beaches, public parks, roads, and other facilities. And I'd also, yes, my lord.
So, but insofar as you have these 5 houses, those areas would not be open to the public.
Indeed, my lord. And so, so the question is whether or not 5 houses is compatible with reasonable access and enjoyment. So in the words is reasonable access and enjoyment. So in order to make that determination, the governor in my submission, and obviously if he came to a wrong decision, the court could review that, would have to carry out an analysis of the development as a whole to consider what benefit it brings and whether or not those 5 houses would have the effect of unreasonably interfering with the public's right of access and enjoyment. And I'd also ask your lordship to bear in mind, and as the Court of Appeal found, and against which there's been no appeal, is that the development was seen as a means by the governor of making the park accessible. So if you can't access the park, because it's not reachable. There are no facilities there, no docking facilities, no marina. That is a matter in my submission to be taken into account. So it's the section in my submission requires, at least in relation to the proviso, requires some element of give and take. And so it is not a requirement that the public must have, as I put it in my written case, unbridled access to all parts of the park at all times for all purposes. And I would submit that that was a factual question, which required the governor to carry out an analysis, a factual analysis of how that would impact the public's right of reasonable access and enjoyment. So it would be the wrong approach in my submission to single out particular components of the development and say, well, this may interfere with public use without considering the overall impact of how the development assists in making the park accessible and enjoyable for the public. That would be my answer to your lordship's question.
So would it follow, Mr. Mizik, that if one had the benefit of a development permission to subdivide, including residential plots, one then came along with an application for a development permission for, say, a block of flats, maybe a small block of flats on one of these plots, the governor would be well within his entitlement in the scope of that discretion say no?
Yes, I mean, to take my lord's question, if one plot of land was allocated, say, for a small house, or on the plan it shows a private dwelling, and the governor, sorry, an application comes later on for a 10-story development or a very large house, it would be open to the governor when considering detailed development permission to say that a house of this size, or if this design, or if this character is out of keeping with the national park. But that is not what was said in the decision letter. The decision letter simply say it is not a type of development within the national park. And when that is read in the context of the other communications, which says that it has to remain as a place of outstanding natural beauty, what that was about is that really there ought not to be any development of any sort for now, at least for the time being, in the national park, or sorry, in that particular park. So yes, I do accept that that the governor could have refused the development permission, or detailed development permission, on a number of grounds. But I would submit that he could not do so on the slender ground that it was not a type of development permission, without giving some further explanation as to why. And no further explanation was ever given. Check it out. So those are my submissions on issue 2, and if I could address the other 2 issues. First, issue 3, which deals with the whether or not the Court of Appeal ought to have entertained the application for constitutional relief, because that's what issue 3, that's the way issue 3 is framed before the board. And it was submitted first that there was no jurisdiction, and I understand that it's no longer being pursued, and it could not, in my submission, in light of the decision of the case of Bow against the Queen at paragraph 10, which is in the authorities bundle. Fine. EB 1384 to 1406. Now, as to whether it was appropriate for the Court of Appeal to do so, I would submit that unless the board is of the view that the Court of Appeal made a clear error in doing so, the board ought not to ought not to reverse that decision. And for that, I rely on the principle set out in United Policyholders at paragraph 45. And that is at paragraph 2038. That is at page 2038 of the authorities bundle.
I do apologize, Mr. Missick. If you could help me about this, because it appears that the appellant is content that the matter goes back to the Supreme Court in relation to the question of damages. And as I understand it, your claim is confined to a claim for damages. If I've been understanding it correctly, your case is being, sorry?
Yes, my lord, that is correct.
And but as yet, I don't understand exactly how you are articulating your claim and how the appellant is articulating whatever they say about damages. And so the point the appellant makes, basically, is that the constitutional issue should really be tied into an examination of what, if any, damages you're entitled to as a private law matter. And so could you assist by saying what you say are the damages to which you are entitled and defining the basis for that on a private law basis as opposed to a constitutional law basis?
Yes. Well, my lord, on a private law basis, it would depend entirely on whether the agreement in clause 1 of the Shackleton Agreement, by which the governor said he had approved of the land use plan, whether or not that gives rise to an enforceable contract sounding in damages. And as I understand the appellant's position before the board, is that it does not give rise to any claim in damage. Their position is, as I understand it, is that at most, the appellant might be entitled to some kind of restitutionary relief, which the appellant did claim before the Chief Justice, but which the Chief Justice denied, and which the appellant sought to uphold in the Court of Appeal.
Well, the restitutionary relief would be repayment of all the rent that your client has paid, and
Yes.
And then your claim is that it's an enforceable contract, and therefore you're entitled to your loss of profits. Is that in essence?
That is my claim. Yes. But if I don't have an enforceable contract, for which I can claim loss of profits, the restitutionary claim would not be an effective remedy for me, because I entered into this agreement on the basis that I had a realistic prospect of pursuing the development. But I lost that as a result of what I would describe as the revocation of the limited development permission, which prevented me from advancing to any further stage in the development process. And a restitutionary claim in my submission in that circumstances would not be an effective remedy.
But then, wouldn't all these questions of remedy, whether under the Constitution or whatever, wouldn't they best be assessed by the Supreme Court?
Well, they are before the Supreme Court in a way, because the Court of Appeal has remitted the matter back to the Supreme Court. So I'm a little I'm not sure why the appellant is asking you to reverse that decision, because I understand what they are asking you to do. So I don't want to spend an enormous amount of time on developing what I would say would be the why I have a constitutional relief if your lordship's of the view that it really ought to go back to the Supreme Court before your lordship hear these arguments. But to put it very simply, what my arguments might have been or would have been are these. First, if I did have a development permission to subdivide land, that permission could only be revoked by the governor paying compensation. And I say that by preventing me from making any further steps, taking the next step in the process. That is what the governor has effectively done. And if I did have development permission, whether or not it's recorded in the register, for which I have no responsibility, that is a property right. And if I am deprived of that right by the governor revoking that permission without going through the statutory procedure that's set out in Section 41 of the PPO, and had the governor done so, I would have been entitled to make a claim for compensation. But by not following that process, I've been denied the right to compensation under the PPO. And so, if that is the case, and again, subject to me not having any other effective remedy, that would be a clear case of deprivation of property, whether under the 2006 or the 2011 Constitution, and no question of justification arises. So that would be the simplest way I would put the case based on the Constitution. If I did not have the development permission, I would say that Clause 1 of the settlement agreement, in the context in which it was written, amounted to a clear representation by the governor that he had approved the use to which this land could be put. Because it was a land use plan, which was attached to an application to subdivide land. And he made that assurance, he gave that assurance for two reasons. One, in return for me abandoning my claim against him, made at the last moment when the matter was about to come on for trial. And then secondly, for his own use, because as the Court of Appeal has found, he wanted the development because he thought the development would assist in making the park accessible to the public. So even if I did not have the benefit of development permission, there was this representation. And even if the development permission upon which I relied on was ultra-virus, that in itself would not prevent a claim based on legitimate expectation. And of course, it is true that in the fact that a public authority lacked capacity to make a promise or give an assurance is an important factor to be taken into account. It is nevertheless only one factor. And in the particular context of this case, it is not in my submission a factor which would operate so as to deprive the respondent of any relief. The respondent is not asking the appellant, or is no longer insisting that the appellant allow the development to be carried out. Taking Tuliki out of the national park with a proposal coming from the appellant, it is not one that the respondent pursues or was pursuing in these proceedings. All that the respondent seeks is monetary compensation. It is monetary compensation in respect of a specific assurance in relation to a specific matter. Made to the respondent and no one else. It does not set any kind of precedent. Now, before the board, for the very first time, the appellant has advanced a broad public interest reason why the governor was correct in resiling from the promise. And in particular, they rely on the provisions of Section 18 of the Constitution, the Crown Land Policy, and the Crown Land Ordinance, and various other environmental matters. But none of these form the basis of the decision in 2009. None of them form the basis of the decision or was put before the Chief Justice. They were not put before the Court of Appeal as the reason for denying relief under this head. And if I could point your lordship to the decision of the Court of Appeal in which the sole reason given for saying that the interference was justifiable is at paragraph 60, what the Court of Appeal found at paragraph 60, which the Court of Appeal recorded. Alternatively, Ms. Hippolyte submitted that if the court is considering this ground, takes a view that there was interference, then it must go to consider whether such interference was justifiable in the public interest. She argued that the concept of what is in the public interest is really extensive, and we respect the legislator's judgment as to what is in the public interest, unless it's manifestly and without a reasonable foundation. Fine so far. She stated that the justification is grounded in the provisions of the NPO itself, which is to safeguard the interest of the public with respect to the accessibility and enjoyment and use of the national park. So throughout the entire dispute, leading all the way to the Court of Appeal, the objection was based entirely on the construction of Section 418, not on any broad policy grounds or general environmental consideration. The test of whether to allow a development to take place in a national park was not altered either by the Section 18 of the Constitution or the Crown Land Ordinance or by any of the other policies that is referred to. So in my submission, the appellant did not, in the Court of Appeal or in the decision taken in 2009, put forward any reasonable broad policy reasons to refuse to allow the appellant to proceed on to the next stage, relying entirely on the construction of Section 14, so Section 418 of the NPO. And just to wrap up on this, the appellant's case is that it would be a strange and certainly an unjust outcome if the appellant, having strenuously opposed any form of other relief, and having regards to its own conduct, that's how the matter proceeded from 2006 to when the proceedings were issued, should be able to, with any degree of seriousness, invite the board to deny the appellant any form of compensation, or any compensation that would not reflect the bargain that was struck between it and the respondent in 2006, when the when the settlement agreement was executed, and which was intended to benefit both the appellant and the respondent. So that in an outline would be what my submission would have been, if the board was willing to consider the constitutional question. I deliberately made it short because of the indication that the board's given. So unless I can help you further.
It was only me speaking. It wasn't the board. I make that clear, Mr. Missick.
Well, my lord,
I wasn't meaning to give an indication either.
Well, my lord, I do understand the import of the question, and so rather than going into chapter and verse, I think I've outlined it in sufficient detail to give the board my indication, if you like.
Thank you. Does that
So
complete?
unless I can help, unless you have any questions for me, then those are my submissions.
Yes, Lord Sales has a question.
Yes, I just want to raise it before you stop, Mr. Misrick. If you could look at section 29 of the PPO, page 634 in the bundle.
Yes.
And what I wanted to ask you was whether it might not be said that it's section 29 itself that explains the effect of all the different permissions. Because if you see the structure of A, B, and C, it says outline permission, the effect of which is to give to the grantee approval in principle. And then it's the same structure for each of A, B, C, and D. And might it not be said that your submission as to the effect of permission to subdivide land is in effect to treat it the same as outline permission? Because you, as I understand you, are saying that by giving permission to subdivide land, you get approval in principle at least to the use to which the land can be put, even if details have to be filled in later. And what I wanted to put to you was, how do you respond to the point that that might be said to be inconsistent with what is said expressly in section 29, where if you want permission in principle, it's outline permission that you need?
Well, I understand the question. What I would say is that these are different levels. So outline permission is certainly a higher level of permission, but if you've been given permission to subdivide land, that does have a legal effect. And in my submission, the effect is not simply that you could physically chop up the land. And it does not go as far as approval in principle for the development in the case of outline development permission. But it does establish use. And use in my submission is of itself a form of development. It establishes use. And as I understand the way how it is treated here is once the use has been established, that use is the ground floor for making any subsequent application.
Yes, thank you. And may I ask you one other question, please? If you go to section 63 of the PPO, which is page 659 of the electronic bundle, and this is the provision which says what should happen where there are environmental issues in relation to an application for permission. And essentially, the applicant has to prepare an environmental impact assessment. And then section 63(3) says the director shall prepare a report on any application for development permission for development in respect of land in a conservation area. And such report shall take into account the impact statement prepared in respect of the development and shall be appended to the application when it's sent to the board. Do we have the relevant report by the director on which you rely in this case?
Well, my lord, it's not in the bundle, but the report would obviously be a matter for the appellant. It's not a report that would come to the respondent. It has never been, in my submission, it has never been the case, the position taken by the appellant that this never happened or that it never existed. I am told that during the course of the proceedings in the Supreme Court that the court was told that a number of the documents relating to this matter are no longer available because there was some flood. But so it is once.
Right. Well, no doubt this is a matter that can be dealt with if it's able to be dealt with in the memorandum that you're both going to submit. But before we leave it, one thing that I've been struggling with, if I may say, on your submissions is the idea that the application for permission to subdivide made in 1994 remained extant so far as Scilly Quay was concerned in 2006, because wouldn't it be fair to say that the impression from the papers is that all sides, both the respondent and the government, regarded the matter as having been dealt with, it may be wrongly, but as in fact having been dealt with by the subdivision permission granted in 1994. And if that's right, might it not be said that there was, on an objective construction of the position and the documents that have been brought into existence, no extant application for permission to subdivide in relation to Scilly Quay on foot and calling for a decision in 2006?
Yes, well, my lord, I've advanced my case on the basis that there was a deferral when the matter came before the governor in 1995. He deferred that decision, and in deferring that decision, he never made it a requirement that a new application be submitted. And
no, sorry, Mr. Just to be absolutely clear, he didn't say he was deferring it. There was no decision saying that. And the impression I rather got from the materials in the case is that no one thought it had been deferred. Everyone thought it had been dealt with by the grant of the permission to subdivide in 1995. But if there's something that shows on the facts that I'm wrong about that, I would welcome being indicated, you indicating where that is.
Well, my lord, I would have to have a look to see if there's any documents pointing in that direction. But on the basis of the facts and the documents before the court, I rely on clause 11(3), which says that the government would favorably consider, that is clause 11(3) of the 1995 lease, at a future date. That date being when Scilly Quay, when the peninsula development was 60% complete. And that occurred in 2000. And immediately that occurred, the respondent sought to advance the development by seeking additional permission. And you will recall at page 225 of the bundle, that's when they were told that it was not of a type of development that could be permitted in the park.
Yes, thank you very much indeed.
Thank you, Mr. Missick.
Thank you, my lord, my lady.
Ms. Manfield.
Thank you. May I start with the question that Lady Arden asked about whether the plots on Scilly Creek are strata titles? I don't yet have a factual answer to that question, I'm afraid. But a strata title, I think, is irrelevant in this context, because title, strata, it's a species of title to property. And the idea is a bit like a flying freehold in the United Kingdom, or it's a different concept, to enable people who own condominiums to have some kind of title to their apartments. Whereas when one was looking at parcels of land for development permission purposes, the issue whether there's permission to divide or subdivide is about plots of land, pieces of the underlying soil or water indeed. You can see the definition of a parcel on page 620 in section 2 of the Physical Planning Ordinance. So even if one parcel of land were held with some kind of strata title, then that parcel couldn't be more than one parcel of land for the purposes of planning legislation unless a successful application were made to divide it. If I then turn to my reply to Mr. Missick's submission, can I first deal with the question of what permission to subdivide allows? I would start, as Lord Sales did a moment ago, in a question with the language of section 29 of the Physical Planning Ordinance on page 634. And we say that it's quite clear that permission to use land in a particular way is an outline permission, not a subdivision permission. And unless, of course, the subdivision itself sets some sort of condition. Perhaps it might be you have permission to divide this land, provided you use it for a road or something like that. And we say that the point of subdivision is that then one could then sell individual plots separately, or they could be permission for particularly different uses could be made for those separate divisions. But Mr. Missick is wrong when he says subdivision authorises the type of structure that can be built and the use to which a plot can be put. And we say that's not how the statutory scheme works, and that submission elides sections 29A and 29C of the Physical Planning Ordinance. And I think I did show you in my submission, but on page 442 is an application for permission at Scilly Creek, which shows that all three applications were made in relation to that land. Now, I don't say you can't jump straight to asking for full development permission without asking for division or outline permission first. You can go in where you want on the process, but application or permission to subdivide and permission for outline use are different things. I then yes, Lord Sales.
Can I just check? Presumably on the register, particular planning permission is tied into a particular plot of land. Yes,
my lord, I believe right? I believe so. If we turn, I'm going to turn to it in a moment, but the 1994 subdivision permission, you'll see that it has an application number. It's page 298, I'm sorry. It has an application number and then block and parcel number. And in fact, that's for two parcels of land, 58 and 4. But yes, it does an application for permission of one kind or another, as I understand it, ties to a parcel or parcels of land.
Do we have what the register says in relation to Scilly Creek and Scilly Quay?
Not in the bundle at the moment, my lord, but I presume that we'll try to get it as part of the answer to the question that Lord Lloyd Jones.
But as I'm understanding your answer, you say that on the register you get a particular permission linked to a particular plot of land. And if you want a permission linked to a plot of land which has been subdivided, you have to apply for subdivision, and then it'll appear on the register that the subdivided plot has a particular permission attached to it. Is that right?
Yes, that's my understanding.
All right, thank you.
Yes. So to take an example, my lord, if you had an island, a small island, part of which was environmentally sensitive or prone to flooding or something like that, and you wanted to ask for outline permission, and you thought there might be an objection if you asked for the outline for the whole island, you might first ask to subdivide and then ask for permission for particular use for that bit of the island that you thought it was a sensible application for.
Thank you.
Yes. So then turning to the effect of the 1994 application to subdivide, Mr. Missick says, as I understand it, that the 1994 application in itself gave no right to a particular use of Scilly Quay. Rather, the decision on the 1994 application was to make a recommendation that subdivision should be allowed, but that then lay on the file, as it were, and was deferred until 2006, when the governor picked up that 12-year-old recommendation, considered it, and made it unconditional, an unconditional right to subdivide and use the land for residential purposes by means of the 2006 settlement agreement. But that analysis doesn't stand up to scrutiny, given the structure of the legislation, and nor does it bear up on the face of the documents. If I could ask you please to turn to page 635, which is section 30 of the Physical Planning Ordinance. Section 30 says that section 30 subsection 1 says an application for a grant of planning permission shall be submitted to the board through the director. And then subsection 3 says that the director shall notify the applicant for development permission in writing of the decision on the application. Then if one turns to the regulations, which are in the supplementary bundle at tab 5, page 32, regulation 9, which I didn't take you to in opening, I don't think, on page 32, that gives the board an express power to defer consideration of an application if it wants to, or to until it's received further information, or if a certificate is required under section 31. So there's a power to defer. And again, regulation 11 provides that a decision must be notified. The director must notify an applicant for some form of permission within 10 days in the form set out in Schedule 1 of a decision reached on an application. It's important to note in Regulation 11.3 that time begins to run in respect of a decision given on an application from the date of receipt of the notification. So you'll bear in mind that section 37 means that there is an important, when you got this and how long the permission lasts is a material question. So that answers that question. And Regulation 11 subparagraph 5 says that for the avoidance of doubt, it is hereby declared that for the purposes of legal rights, a decision is and liabilities, a decision is made under these regulations when it's notified to the applicant, and no form or manner of notification other than that provided for in this regulation shall give rise to any rights in the applicant or liabilities or duties on part of the government or anyone else effectively. Then if we turn please to page 38, regulation 22(1)(c), that's about the regulation 22 is about the register of applications and provides in sub-regulation 22(1)(c) that any decision of the minister, the board or the director in respect of an application and the date, a register of application shall be kept by the director and contain the following information, namely any decision and the date the decision was notified to the applicant. Again, the date is important. And then if one turns to tab 6 and page 39, that lists, that's the first page of Schedule 1, and it lists all the forms. And Form 12 is not a decision to defer, it's a decision to grant development permission to subdivide land, not a recommendation, not a deferral. Now, if we turn to what happened in this case, if I can take you, and I'm aware that if this were a statute, you would not take the first stage of this, but I'm just indicating to you. We look at the index to the record of the proceedings on page 4. Item 25 there is described as a grant of permission to subdivide land. Now, is that an accurate in relation to parcels 58 and 4? Is that an accurate description of that document? We turn to the document itself, which is on page 298 and 299. We see that it is a Form 12 at the top right of page 298. And then we see the title, Grant of Development Permission to Subdivide Land, and the block and parcel numbers. And it's dated the 14th of December 1994. So the suggestion that Mr. Missick made in the last few minutes of his submissions, that clause 11.3 of a lease made in 1995 is relevant, as an assumption that this would somehow be deferred to some future date when 60% of the development on Scilly Creek had happened, can't be right, because clearly there had been a grant of permission to subdivide land by December of the year before. And it's a conditional grant because it's subject to the conditions in notes 2 and 3 below and overleaf, and the notes at the bottom of page 298 specifically say this grant of development permission is valid for 3 years from the date of notification. And if within that period you have not commenced the development which you have obtained this grant of development permission, the grant lapses and ceases to have effect. So on any view, whether one looks at section 37.2 of the PPO or the specific terms of that grant, it simply had no relevant effect by 2006, even if the 1994 decision did amount to some deferred or conditional grant of permission to use land for a particular purpose, and we say it couldn't do so. And no relevant work could have started or taken place in respect of parcel 4 because the respondent didn't have any property interest in Scilly Quay until 2006, so it couldn't have undertaken any work there, and it didn't. So that permission certainly lapsed by 1997, and if, and this appears to be the suggestion eliding outline permission and permission to subdivide, but if it had a kind of quasi effect of being outline permission, then indeed under section 37.1 of the Physical Planning Ordinance it would have expired in 1995, but either way it wasn't alive so far as Scilly Quay was concerned in 2006. And if one steps back a little from the language of the statute and the face of the documents and asks, can it really be the case that an environmental impact assessment and a recommendation from a board should stay alive for an indeterminate period, no matter what other environmental or social changes may have taken place in that period? It's unreal. What if that, in principle, recommendation about subdivision of land had taken place in 1984 or 1974? That's why section 37 of the Physical Planning Ordinance matters, that planning matters change from time to time, and it matters that you either pursue your in principle permission or reapply for it in more recent circumstances. So the language of the statute, the face of the documents and public policy all point to that being a document of no effect. So after lunch, Mr. Missick seemed to accept that the 1994 subdivision application didn't have any effect. It was an indication, but what he seemed to say at that stage was that the 2006 agreement, with its reference to permitted residential user in the land use plan, was itself some kind of permission to use the land for the type of development in the land use plan, so far as is material for residential purposes. Again, I say that doesn't work unless the mandatory language of section 14 of the physical planning ordinance as to the way in which an application must be made doesn't apply here, because no section 29A or C application was made. And at that stage, when that point was put to him by the justices of the board, Mr. Missick said, well, there was an application for planning permission. It was made through the normal process. It was made in 1994, which seems to go back to suggesting that 1994 permission did have some kind of effect as a recommendation. If one takes the 2006 settlement agreement on its own, that made no reference to permission to subdivide land. It did make reference to permitted use. So if, contrary to my submissions about how the statute works, the settlement agreement did amount to some kind of development permission in October 2006, it was at best an outline permission. And if and to the extent it acted as some kind of outline permission, then that expired in 2007 because of section 37(1) of the PPO. I then turned to Mr. Missick's submissions on whether some form of private residential development on Scilly Quay as part of the national park was necessarily incompatible with section 4 of the National Parks Ordinance.
Could I ask you just to pause, Ms. Matt,
Yes, of course.
before you go on, because I think it's opportune now to come back to the point that I asked Mr. Missick to help us with. If you'd be so kind as to look at section 4 of the National Parks Ordinance, page 573.
Yeah, sorry, I'm in a hard bundle, I'm afraid. Yes, I have it. Thank you.
It's construe the word the governor may make a grant of development permission for the erection in the area of buildings, the construction of roads, marinas, and such other development as may be considered to be desirable, etc. As I understood Mr. Missick's response, it was that that would include making a decision on an application for development permission to subdivide. It was on that basis, as I understood his answer, that he was contending that the Director of Planning or the Physical Planning Board in 1994 could not have made the decision on the Scilly Quay subdivision application. It was a matter for the governor. That was the foundation of the argument now that 2006 settlement agreement was in fact a development permission to subdivide on the then long outstanding application relating to the key. Maybe that partly at least you've answered this point, but can I just ask you to come back and tell us how you construe section 4 of the National Parks Ordinance?
Yes, well, my lord, in that respect, I say that the National Parks Ordinance, the development permission for the erection of buildings and so on, cannot include permission to subdivide, because if one goes to the definition of development in section 2 of the National Parks Order on page 572, it says it includes any change of use. It doesn't say it includes subdivision, it's a change of use. But in any event, section 4 doesn't actually talk about that wide definition of any development. It doesn't say the governor may make a grant of any development permission in the national park as may be considered to be desirable. It says development may make a grant of development permission for the erection of a structure. So in section 4, his only power is for buildings, effectively.
Thank you.
Mr. Missick said then, still staying with the language of section 4, that some private residential development was not necessarily incompatible with the language of section 4, language and purpose of section 4 of the National Parks Ordinance, because by virtue of section 7 of that ordinance, private land ownership is permitted in a national park. So he said as the permission of judgment as to whether some private residences are compatible with reasonable public access and enjoyment to the national park. Now, we certainly accept, and we have to because of the language of section 7. I'm sorry, it isn't section 7, it's section 5. I'm sorry, my mistake. Section 5 is the inclusion of private land in a national park. But we certainly accept that private ownership is not necessarily inconsistent with national park ownership, and thinks of privately owned estates that have a right to roam over them in the United Kingdom, in various parts of the United Kingdom, for example. But what is inconsistent with the language of section 4 of the NPO is development of private residential accommodation, because Mr. Missick didn't focus on the precise language of section 4.1a of the National Parks and Ordnance when he said that one was looking at what was compatible with reasonable public access and enjoyment of the national park. He seemed to be suggesting it was a matter of give and take, evaluation, what was compatible with reasonable public access to a reasonable proportion of the national park. But the statutory language in section 573 is precise. It starts by asserting that an area which is designated as a national park shall be open to members of the public for recreational use. So that's the first thing. It must be open. It's mandatory. The second point is that the governor can only make a grant of development permission for the erection of buildings and so on, as may be considered desirable to facilitate enjoyment by the public of the natural setting of the area. So he's limited only to that development which may objectively be considered desirable to facilitate enjoyment of the natural setting of the area. It must be open. Does this building help make it open? Perhaps a block of lavatories might, conceivably a cafe might, but a private residence can't. And then, and this is important in deciding whether or not such a development is so desirable, the paramount consideration shall be the minimum consistent with the reasonable access to and enjoyment of the area by a member of the public. So if, for example, in the national park, one was saying, this is a popular picnic area, let us erect a block of lavatories and perhaps a campsite kitchen and perhaps a restaurant, one might see that that was a building that might be considered desirable to facilitate enjoyment by the public of the natural setting. But then the paramount consideration would be what is the minimum consistent with that. So it isn't just a broad evaluation of what is reasonable public access, it's the minimum consistent with reasonable access and enjoyment of the area, which must be open, shall be open to members of the public for recreational use. And we say it's on that language, it's absolutely evident that the Chief Justice was right and was the decision maker in November 2009 to hold that residential development was simply incompatible with that statutory language. On the point, on the question of legitimate expectation, my lord, the relevant qualification we say was the need to comply with planning law, and I referred you to the relevant clauses in the 2006 lease in my own submissions. I think I referred to you, but I'm not entirely sure, to the document on page 379, which is a letter. I think I may have taken you to it rather quickly. It's a letter to the Director of Planning, Mr. Clyde Robinson, on the 2nd of October 2009, in which he is asking him to confirm, he's trying to get a comfort letter that the land use described in the master plan for Scilly Creek has been approved and remains in force, which he didn't get, and that you granted a development permission to subdivide land, and so on. And then he says, I also understand that the approval process has to follow the rules established in the National Parks Ordinance and its reference in section 4.4. So he understands that there are relevant qualifications. Mr. Missick suggested that this hearing before the board was the first time that a broad so we say there is a relevant qualification, and you have heard my submissions that because any promise to allow residential development would have been ultra vires, it couldn't have found a legitimate expectation. But then Mr. Mizik said that this hearing was the first time that a broad public interest reason had been advanced for resiling from the promise, if there was such a premise and it could otherwise be enforced. Now, obviously, Mr. Mizik was present in the Supreme Court and the Court of Appeal, and I was not, so I don't know precisely how the point was put. There may be aspects of the way I put it that weren't advanced in those courts, but I don't. And I should also say that I do, of course, accept that the 2009 refusal decision itself did not deal with reasons for departing from any alleged legitimate expectation, because the 2009 decision was simply a decision on the statutory application for planning permission, and said you can't have planning permission, it would be contrary to Section 4 of the NPO. But as I see it, the Court of Appeal did consider the submission that there were public interest reasons for resiling from the promise between paragraph 67 and 70 of its judgment on pages 101 and 102, and indeed cited the evidence on this from Mr. Leroy Charles. It was not very impressed by it, but it did cite that evidence. And my submission is that when this court is looking at the question of whether there is a proportional reason for resiling from a legitimate expectation, if there was such an expectation in the first place, which you don't accept, but the question for the court on whether there's a proportionate reason for departing from it is for the court's own evaluation. The court says if there were such a promise and it was sufficiently devoid of qualification and it wasn't an ultra vires promise, would it nonetheless be proportionate for the decision maker to depart from it? And of course the decision maker must advance the evidence upon which the court reaches that decision, but it is for the court's own evaluation, and it isn't a question of whether the decision maker considered that question itself or rationally concluded that there were proportionate reasons. That's not the question which the court is advancing. I then turn to the question of whether
we're running over rather, Ms. Manfield, I think. One on the clock, please.
Yes, my lord. I am going to be very brief. It's the question of whether the Supreme Court had original jurisdiction to determine the constitutional claim, whether the Court of Appeal should have done so without a first instance argument on this. The respondent said that Beau and the Queen was against me on this, but in my submission, that's a misunderstanding of the point that I was making. The Supreme Court had original jurisdiction to entertain a constitutional challenge. Of course, in an appeal, like the Beau case, which is an appeal against sentence, one could make constitutional arguments about why the sentence advanced was unconstitutional, but it's not here. The Supreme Court, which was the entity which arguably infringed the respondent's rights, and at least as a question of restraint, neither the Court of Appeal nor this court should have decided if there was some breach of a constitutional right to property before the assessment of damages in the Supreme Court. Finally, what, if any, damages should the respondent be entitled to as a private law matter? We say that it is a matter for the Supreme Court to decide on quantum, but we say it should be done by the reference to the four following principles. Firstly, that any 2006 contractual promise to permit residential development in the national park was ultra vires and therefore void and of no effect. There may have been some other valuable elements of the agreement. The difference, so the question then would be, what is the difference in the value of the lease with that promise and without it? Not the profit the respondent might have made, but the difference in value. And that would also be the test on unjust enrichment. And I don't understand Mr. Smith's submission about why that isn't an effective remedy. It may not be the most valuable remedy for his client, but it is an effective remedy. The Chief Justice didn't deny that that claim existed. She said it wasn't the way it was pleaded, and it doesn't appear that it was. You can see that on paragraph 118 of the pleading. But we accept that she ought to have heard the quantum argument separately, given the order for a split hearing, and so it's still open to Mr. Mizik to make that argument there. So I'm sorry, apologies for running over a little, and I see that Mr. Lord Sales has his hand up.
Sales has a question for you.
Yes, I'm sorry to take up more time, but I'm struggling slightly to see why you're conceding that there is a private law claim.
My lord, I say there can't be a claim on the promise. An ultra vires promise can't have effect, it's void. But there may be some that doesn't necessarily follow that the whole lease is void. There may be other elements of the lease that are not void. Alternatively,
just to cut this short, so you say that the promise, in clause 1 of the settlement agreement, did constitute a promise to grant or procure planning permission, do you?
I don't, because I say that it was subject to other clauses of the lease, but to the extent that it did, I say it is void, and that has no effect. There is a claim in the claim form, paragraph 118, for unjust enrichment, but then it isn't pleaded as unjust enrichment. It says the loss is the appellant's unjust enrichment is the same as the respondent's loss, which is said to be the profit it would have made if it had a lease and sold the house, and that's not the right measure. And as I understand it, the Chief Justice...
Sorry, I just wanted to be clear. Are you accepting that there was a breach of the obligation in clause 1 of the settlement agreement?
My lord, clause 1 of the settlement agreement was an ultra vires promise. So I'm saying that to the extent there was, it was simply a void promise. It had no effect at all.
So I think your answer then presupposes that had there been power to make the promise, it did constitute a promise.
Yes.
All right, thank you.
And Lord Stevens has a question.
Yes.
I'm sorry for coming back to it, but the lease also potentially can give rise to a claim. Either the whole, I just want to know what we have to decide, because the permitted user clause is completely defunct. You can't use this land in this way at all. And either the whole lease is void, in which case you have to repay all the rent, or that you're in breach of your obligations. And I'm not quite sure which the one, how it's being defined by the appellants.
My lord, I would submit that the most that could be, the most that the respondent could expect would be, if in light of a void promise, would be some form of equitable remedy for unjust enrichment, i.e., the return of the rent.
But then you're saying the whole lease is void. You in your skeleton or in your case, you said the blue pencil could be taken to the various clauses, but the actual lease itself, the permitted user, just cannot take place.
Well, my lord, the permitted user referred to there may not, but it's national park. It can be used for bone fishing. It can be used for picnics and so on. So that may have some value, which is why this is not something that's been fully ventilated, and it may be that there is some residual value of the lease. So that I say the most, if the lease is simply valueless, the most the respondent could expect is the return of all the rent. But it may be that there is some value to the lease even without this user. And so that's what I say ought to be considered before the Supreme Court in the split quantum hearing.
Thank you. I don't think there are any further questions. Well, thank you, Ms. Banfield. Ms. Banfield, Mr. Missick, I'd remind you then that we'd be grateful to receive, please, an agreed note of the setting out the planning history of this matter, and appending any documents which are not already in the bundles, also including cross-references to those which are in the bundles, would assist us greatly to have that in a single document. When I say the planning history of the matter, I mean the planning history relevant to the issues which the board has to decide, not inviting you to include all of the planning applications which may have related to other plots which are relevant to the matters that we have to decide. We're very grateful to you both for your submissions, and also to those who sit behind or alongside you, and those instructing you through preparation of the matter. There's been a lot to get through today. The board will now take time to consider the advice which it will tender to Her Majesty. We're very grateful to Council for their assistance this afternoon. Thank you very much.
Thank you.
Court is now adjourned.